afternoon, Mukul. Thank you so much for your time today. And my name is Dinesh Sharma. I'm founder of Volody, and we help businesses in digitizing the whole contract lifecycle management, working with global corporations. And the idea of this call or this conversation with you is to understand you well and how your journey has been so far, working for global corporates, and then also to give a lot of insights to the legal professionals who are working at lower level or mid level in the corporate, and who or the lawyers or graduates who are aspiring to become lawyers. I think your experience of more than 2 decades will be very, very beneficial. So that's the whole objective of this conversation. So I'll just quickly, we'll give you some opportunity to, introduce yourself, and we can then, during the conversation, we'll talk about many things. So I think this will be a very interesting conversation today.
First of all, thanks, Mr. Sharma, for having me. It's such a pleasure and privilege to have this conversation with you. And I've gone through your profile also. It's a wonderful profile, very interesting journey you also had over the course of years. Exceptional journey. So absolute pleasure to be here discussing my journey as well as a variety of other things for the young generation. So I'll start. So as you said, almost 2 decades back, around 2002, I graduated and started my professional journey. So I belong to a family of lawyers and judges. So obviously law was something which is like in the family. My father was a judge, uncle is a lawyer, and uncle is a judge. So it is in the family.
Wow.
So started with practicing practicing law in Rajasthan High Court, Jaipur. Practiced in civil side, criminal side, some arbitrations at the time, Section 11, Subsection 6 applications for appointing of arbitrator, etc. Used to come to Rajasthan High Court. So I used to do all those things and practiced from 2002 to 2006. So 4 years practice, had different matters. I was academically a good student, so I enrolled into LLM, cleared my LLM, also masters, and then enrolled into PhD. In 2002, there was this new law which came, Competition Act. And that interested me that, okay, why this new law is required, and what was this earlier MRTP, Monopolies and Restrictive Trade Practices Act, and why it was what it was not catering to, and why we needed a new law called competition law, what was the necessity of having this law. So that interested me, and I enrolled into a PhD into the trade law and competition law. That when we have all the anti-dumping duties and all these trade laws, how this competition law is going to add value to it? Because MRTP, people used to say, is completely toothless tiger. So what is there in competition law? That interested me. So I enrolled into PhD. And then I used to go to, and since it was such a new topic at that time in 2005, 2006, much material was not available in Jaipur University. Therefore, I used to go to, and there was this national law school that opened in Jodhpur. So I used to travel every weekend, Saturday, Sunday, from Jaipur to Jodhpur for my research purposes. And there, the vice chancellor was kind enough to allow me in, and then he was an expert in trade and competition law. So he guided me also that, okay, you read this material, this book from on this topic from this particular author in the US and UK, because at the time in US, UK, and Europe, the competition law regime was well established. So he really guided me a lot. What has been the interaction between trade law, competition law, and this is how I used to travel from Jaipur to Jodhpur every weekend. Now, when I was in Jodhpur and NLU, I used to study and research for 2 days, come back, and then start and do my practice here. So the vice chancellor, as well as my guide, the dean of Jaipur University, both of them, they advised the vice chancellor of NLU Jodhpur and the dean of Jaipur, my PhD guide, that why are you sailing in 2 boats? You have to choose one boat, either be a completely litigating lawyer, focus purely on litigation, or else focus purely on research. Because if you keep on sailing in 2 boats, this is not going to lead you anywhere. Ultimately, you will neither be here nor be there. Then I thought that I was so much invested into research. I thought, okay, let me just take research completely head on, and litigation we can do later also. So like that, how I started my research career. And then at the time, NLU Jodhpur had an opportunity of an assistant professor who can teach competition law, trade law, and can teach criminal laws. It was very vacancy curated for me, it seems. So I just applied, got through an NLU Jodhpur, and then I used to teach competition law and also teach criminal law and CRPC and IPC. So this is how my journey shifted from a litigating lawyer to an academician, and I joined National Law University Jodhpur. I completed my PhD and continued there. Then became chief warden also there, and spent some good 3.5 years. So that's how my career from litigating lawyer shifted to academician. Now, once that was over, I thought that let me have a regulatory exposure. Then when I was doing my research, and by 2009, Competition Commission came into being. So I was thinking that, okay, how the regulator will think and how what is the regulatory strategy for working on these things. So at the time, that made me inclined to let me just join some regulator to understand the in-hand experience of a regulator, and that's how I start writing examinations for whatever Competition Commission, RBI. Somehow got selected into RBI. Though my research was on competition, but then that's how luck has been, and that's how the competitive examination was selected into the Bank of India. I in fact topped the All India examination 2009 of
Wow.
RBI.
Wow.
So yeah, so joined the regulator, joined RBI, and spent 6 years there just to have a idea that how a regulator thinks. Now in RBI as a central banker, I spent time in 3 different departments. So first was with the Foreign Exchange Department. Spent 2 years there understanding about the FEMA regulations.
Really?
Then I was with the Department of Banking Supervision for 2 years. And then I was at so at the time Mr. Ramadan had come, and he had come with his on-tap banking licenses. So all this Paytms and Indian
Wow.
Bandhan Bank and India Post, they applied. And so we were in the committee to make notes for the top management, governor, deputy governor, so that they can decide on whether whom to give licenses or not. So I was in that committee making all those things. So that's how what I spent my time into RBI. And now, whether RBI had a policy that after 5 years you can go into any course and RBI will pay for it. RBI is a wonderful employer in that sense. So after 5 years,
Really?
when I wrote my GMAT examination, got selected to IIM Ahmedabad for the Volody MBA program. So then I joined IIM Ahmedabad. I did my MBA from IIM Ahmedabad. And after that, I was campus placed to RPG Group, and that's how my corporate journey started. So since I was still in RBI, so I took sabbatical, but then post my IIM Ahmedabad was selected as RPG Group. Through campus placement. Therefore, I resigned from RBI. RPG Group paid whatever money and penalty has to be paid. So that was paid to RBI. And that's how my corporate journey started around a decade back. And from RBI, when my corporate journey started in RPG Group, I handled 2 profiles. One is obviously, given that I was a lawyer and I was handling legal profiles. So one was they made me the chief manager for the legal matters, at least for the international business of theirs, as well as they have given me a solar business development profile also. And I was also the SPOC for their TBCB project, which is tariff-based competitive bidding, whereby we won a PPP project in Bikaner Stika. So I was handling a dual business role as well as the legal role there. Interestingly, that was a wonderful experience. Then I went to Canada for an arbitration, spent some time there. So it was a good time there. Then I got promoted, and I was handling the entire legal for a variety of divisions. The solar business somehow could not do well because of a variety of reasons. There was a lot of tax issues, and the government policy changed in between. The solar business somehow got stagnated, and that did not develop further. But that it gave me a great experience and exposure. Then from RPG Group, I was shifted to Adani Ports and Logistics, heading the legal profile there for all the ports and logistics. Spent 3 years almost there, or 2 years there. Then from Adani Group, I went to Westpun. I will not take a lot of time. Adani went to Westpun. In Westpun, I will come to Cube Highways as General Counsel. Yeah. So Cube Highways basically is a private equity fund, Singapore-based company. So we are into Indian toll roads. So we acquire roads and collect tolls from the users and run it for 20-25 years. So that is what the journey has been.
I must say, very inspiring story, sir. I think Mukul, and anybody, watch this 5-7 minutes of your discussion will get inspired so much that coming from a family of lawyers and judges, and getting into law was possibly a part of your blood, I guess, I must say. But then, having a variety of experience and going very systematically, doing the PhD, getting into the college to become professor, and then to RBI to understand the regulator mindset, and then doing post graduation from IIM Ahmedabad, which is the MBA college in the country, number 1 college in the country. So I guess I think very inspiring story, Mukul. I must congratulate you for that.
Thanks.
And in your current role also, I think in the corporates you work for, these are all global giants, RPG or Adani or Welspun, or you talk about Cubanation, all global giants. And I think the kind of work you are doing, it's not anybody can do it. One is that. Second is that very lucky people get these opportunity to work on those complex transactions. Your kind of business, any transaction you work on, these are not routine transactions. I can tell you from my own experience. And you, while working for RBI, you're saying you were part of the frame committee where all the framework policies were written for the new age banks like all the digital banks in the country. So I think the learning you got is commendable, and I think you must be really working at least 20 hours a day to get where you are today. And even today, also on Saturday, you were able to give a time to us to give this meeting. Very commendable. I think this. So, Mukul, I just have certain questions, to you, because these questions will definitely help the community, and also maybe people in the industry also will get to learn a lot about it. So, you are a GC now for almost, 7, 8 years, maybe 10 years in the GC role. And, GCs are very critical for any business, the way the whole, the legal framework is taking shape and the challenges coming up. Do you think, GCs should be part of the board of a company, because they are sort of a strategic, these are very strategic position now, and they should be part of the decision making at a board level. So what is your thinking? Because I don't see many GCs are part of the board. Very few large companies have got GC, but not many GCs. So what do you think about it?
First of all, Mr. Sharma, it just shows your experience and your grasp over things that you asked the most pertinent question, which right now is keeping all the GCs and the legal minds and corporate fraternity engaged. This is the topic which is right now a burning sensation for many. You rightly said. But before that, I'll just try to explain the two mindsets that are going on in the country. So primarily in India, I feel that there are two types of corporates. One is purely a promoter-driven corporate, whereby one person has really done well, and then he has a vision, and then the entire corporate, they all go as per his vision or his. So he is one clear leader who is leading, and all the things accordingly then set based on what he thinks is priority. He may have his own personal biases at times, so he may think that legal is very important, so GCs can become a board directors there, or he can think that finance is important or HR is important, but depends on that individual at times. So there's one set of corporates where this individual or some family members are running it. Second is very professional driven setup, whereby the promoter is just taking an overall kind of a what you call just a reporting kind of a thing, but the entire the management is run by the professionals, and then they play a particular role in running the business. So there are two models which right now going on. Now, in both these models, the role of GCs or head of legals, of chief legal officers, or whatever name you can call them, the roles are different. Now, when it comes to the Indian corporate, and I have been fortunate enough to work in both sides, also in the regulator, so I can explain the perspective of all the three. First of all, so far the Indian promoters are concerned, see, for them, it is the business which is very important, and they want to keep the legal person away from the board decisions. Because see, if in a board you are doing a very freewheeling discussion where independent directors are there, and if the GCs is saying something which they think may not be put in a way which maybe those independent directors will get comfort. So therefore, they will feel that there's a big risk having a legal person there. So they want legal person away, want to discuss something in the board, go to a legal person and ask him to find solutions, if possible, within the regulatory framework, and then come with the answers. Instead of having this person there and saying something which may then create, he may not say in a negative sense, but then it can be seen as something which is not legally correct. Because at times you don't have the answer done in there for any legal question that I asked to you. So how independent directors will think, and therefore the promoter may have that skepticism in mind. Not that he will not rely on his GC or his chief legal officer, but then he will not like to expose that straight away in the board, and therefore he'll like to keep the board away from the conscience keeper of the company, the GC, and would like to take some decisions, go to GC and see what is possible. Then maybe I can ask GC to come and present to board what he thinks and take decisions. So there is a possibility. So they like to keep away. So in those corporates, you will find most of the GCs and most of the head of legals, they are not directly exposed to the board. They may be called to board for explaining things, but they are not part of the board discussions and board meetings. So that's what I have seen in life. Nothing right, nothing wrong. So if you are away, obviously then it gives you a broader perspective. You can think easily, you can decide. But if you're part of board meetings, then you understand the risk appetite also at times. And that helps in giving your legal solutions. But then see, everything is interconnected, and law is a discipline. It is completely interconnected to a lot of things, a lot of business scenarios, a lot of geopolitics, a lot of finance, economics, geography. Law is a very interconnected discipline whereby you need to see many things before advising. Otherwise, the advice will not be very savvy for the commercial purposes. It will be very theoretical advice. So therefore, it has both pros and cons. So if GCs are there, they can be valued. If they're not there, then they get a chance to think holistically, give something, and then board can be accordingly satisfied to those things. So there are two models, but mostly in India, where the Indian promoters are there, GCs are not part of the board members.
Very well said, sir. So it's very well said, sir. I think, in coming years, I must say that I think GCs will be part of the board. That's what I personally feel, because CEOs and board are they are definitely understanding the importance of the GCs in the company and how they shape the governance in the company. So that's I personally feel that you're going to be there very soon. And anyway, you are part of the board.
Yes. Yeah, so there are professional driven companies whereby they think, no, let all the stakeholders be there. If there's a responsibility, it is a collective responsibility. Tomorrow GT should not come and say, no, I was not aware about this business scenario, so I do not share any burden for any failure. So every big stakeholder is part and parcel, whether it is a marketing head or it's an operations head or a finance head or the CEO or the legal head. So they all are the HR head. So everybody is responsible for the decision making that the companies take. So the entire executive body is responsible, and not only the CEO and CFO.
Absolutely. And that leads to my next question, sir, Mukul. So, since we're talking about DCs becoming board member, do you think they should be also part of the KMP, which is key management professional, because as per the Companies Act? Because I personally feel that I've been CFO for many years in my corporate role. So I personally feel that DCs are equally capable, equally important to be part of the KMP team as per the Companies Act. What is your personal thinking?
So if I talk personally, so there many people are thinking they do not want to become KMP, and CFOs and CEOs, they feel if they are KMP, it is more riskier for them. But then I feel, in my personal opinion, GCs cannot be kept out of KMP. They should be part of the CLO, the Chief Legal Officer should be KMP. They have to be responsible for the decision making. You cannot be party to a decision when you are completely outside. Because then it's very easy for me to say anything okay to anything. Because then I know that there's no repercussion on me as such. Because if something comes, it will always be on CFO and CEO and at max the CS. So, but when you are a conscience keeper, you are the one who's on the line. You will always be more vigilant in offering things. Traditionally, I feel, as you might be aware, and you are CFO in many companies, that generally the legal role used to fold with CFO, and therefore CFO was the one who was supposed to take all the hits so far as legal is concerned, or secretarial is concerned, or other finance, accounting, technique, and therefore the need was never felt. But now the things have become very complex. And therefore, the legal itself, the nuances are so much, regulatory compliance is so much that CFO cannot take all these responsibilities. It is too difficult to blame a CFO for those things. Itself, finance, accounting itself is too complex, especially all the ESG framework and all those stuff. Accounting itself is so complicated, and the finance itself is so complicated, you can't burden the CFO with even additional legal or regulatory compliance burden. Therefore, I feel that the Chief Legal Officer should be separate. And when we say about compliance, it is not only corporate compliance which CS looks into. There are many other compliances that a corporate has to look into depending on what kind of sector they are in. Therefore, CLOs should be part of KMP, and they should be the one who should take the blame and responsibility also if the corporate is not doing that well. So I feel the time has come to amend Companies Act and make the CLOs KMP. This is my personal opinion.
Wow. So I know many of my lawyers. I absolutely. And which also leads to my next question, Mukul, that you, in your journey of more than 20 years, I'm sure many people must have helped you in shaping yourself as a professional. While you were doing a PhD, or you were in law college as professor, or working for corporates, or working for RBI. How is your professional career shaped through mentors who help you in this journey? So what is the role of mentor you, and where all you found them, and was to work with them?
A very interesting question. Mentors are absolutely required to shape up your journey. And I was fortunate because obviously you need mentors at every stage to help you out. So during my litigation days also, there were great lawyers who were there, who used to go and take their help. Many of them have become Supreme Court judges, like Justice Rastogi. He was used to practice in Rajasthan High Court, Jaipur at the time. Justice A.K. God, he used to practice at the time. So we got so much enlightened by their expertise and their knowledge when they were as lawyers. And we were just starting our career as a fresher lawyer. So we used to go to them for guidance, and they used to really guide us very well. In fact, Justice Rustogi, when he became a High Court judge in Rajasthan High Court, and I used to appear as a very young lawyer at the time, hardly a year or year and a half in the bar, but still he used to give me a lot of audience. Even if I'm talking nonsense, he will just get me out and explain, see, Mukul, we have missed out this main fundamental thing. You have argued everything else around the bush, but not the main thing. And this is what you should master. So there are many great judges. They will give you a lot of means they will really mentor you well. So as a lawyer, you need those things. During my academic journey, again, Professor A.K. Kaul, he is no more now, passed away, the Vice Chancellor of NLU Jodhpur, he had no occasion to help a person. He doesn't know me at all. At the time, he didn't know me at all. So my PhD guy just wrote a recommendation letter, and on that basis, he said, okay, this person is interested in a PhD in trade and competition law, which is a new subject, and therefore he just welcomed me with open arms, and helped me in doing my research and across means whatever guidance he can give despite his busy schedule. That was again a great mentorship that he showed. During my RBI days, our PLA, the ED law, the principal legal advisor, Mr. G.S. Hegde, he again helped us understanding the regulatory framework, what a regulator wants, how a regulator thinks, what you should see, how you should not be a lawyer anymore, but you should be a part of the regulator. You should think as a central banker that every single action of yours are not going to impact just a small company, but the entire Indian economy at times. So you have to be very careful into what you're writing, what you're doing, because the small actions at times can cause havoc in the industry, and you do not want that. You want India to grow all the time, and therefore you should keep those things in mind. So great learning even there. Across in my GC days, great CEOs. Mr. Vimal Kejriwal of KEC, a great leader. He used to tell us how to understand the perspective. A great leader and exceptional boss that I had. Likewise, even Mr. KG Ekaran Gautam Adani, son of Gautam Adani, when I was in Adani, he was a very young guy, but a young person who has a huge legacy, and to have that pressure and still be the CEO of Adani Ports and Logistics and guide things is very difficult, because under him there were stalwarts of the industry. There were CFOs and top CEOs who have spent 30 years, 25 years in industry, people like you. And to have a boss, to boss you around means to be your boss is a different ask, because when Dinesh Sharma will speak something, obviously the boss has to understand that thing and come to a decision. But then he has done a fantastic job, and really appreciate him at such a young age. He was in a position to give leadership. So therefore, it has been a fantastic journey across. And now also in my PE days, there's this person, Mr. Harsh Agarwal. He is the iSpec Capital partner. Again, a very great person, and I really like the way he works. As you said, 20 hours people are working, and despite after achieving so much, they are doing so much. So that gives you, if it's not mentorship directly, but then again, you aspire and you see to those things, to those persons, and learn from their experiences and try to work around and try to so that hunger is still on. So mentors are very important. I've been blessed to have great mentors at us, and so that is, the mentors are required. And if you do not have mentors, find someone, actually go learn from someone, be an Eklavya. If you do not have a Dronacharya straight away. So that is what I feel that people should do.
Very well said. If you don't have mentor, find a one. I think that's one of the line I will remember for many years now. I agree with you. And which also leads to my next question. Mukul, that you, in your journey of more than 20 years, I'm sure many people must have helped you in shaping yourself as a professional. While you were doing a PhD, or you were in law college as professor, or working for corporates, or working for RBI. How is your professional career shaped through mentors who help you in this journey? So what is the role of mentor? Where all you found them, and how easy was? So my if you look at the whole role of a GC, they largely spend time in documentation or contracting process or compliance, etc. And very few GCs has bandwidth which is utilized towards litigation, unless you are in a business which requires a lot of litigation. And then if you look at the whole tribunals or courts, lower courts, high courts, Supreme Court, etc., there there is a need for lawyers to practice. There's a need for lawyers to take the role of a judge. So what is your view about whether there is the possibility of having lateral hiring in the courts, taking GCs or legal counsels in the judiciary role? Do you think that will be they will do a good job in terms of delivering the justice, and also making sure that the backlog of cases goes down significantly? Because I personally feel that they are capable people. They can possibly do a good job. But I'm sure with your experience, having GC and also handle litigations for many years. So your perspective, and coming from a family of judges, so what do you think?
Very pertinent question. Something again which we are right now fighting out. Yesterday I was in a SOCHAM conference along with Mr. Lalit Bhasin. I was sharing a dais with him, and we were discussing this specific point that now the time has come that you should amend the Advocates Act, and the in-house counsels and GCs should be treated as lawyers for all practical purposes, including for elevation, including for filling tribunals. So right now, what I feel is, and this is one thing which is again a personal opinion, and I think we should really work on this. All the tribunals and such kind of quasi-judicial bodies, if you see, they have just become a place where the judges after retirement aspire to be in. And that creates a lot of conflict. Obviously, I'm not saying that they are conflicted in a sense, but then it seems like there's a conflict because then you are doing help, means once post-retirement, you're taking all these tribunal postings. There's a possibility that people can allege that you are helping a particular government to take some advantages. So therefore, that compromises the independence of judiciary, I feel. Therefore, maybe if they need, because now 62 and 65, the age of retirement of High Court and Supreme Court judges is too less, I feel they should amend the Constitution and increase that to a reasonable level, maybe 70, 75, which they think is the right age. So nowadays, because of medical science, so we are healthy until 70, 72, 75 years. We can do a good work. So maybe that is a different question for bigger people to see. But then again, I feel the tribunals, etc., should not only be filled with retired judges, but they should also be filled with relevant industry people. For example, I am spending time in infrastructure industry. Now, if there's a person who has spent 20 years in infrastructure industry, this person will understand those problems better. Likewise, a person who has spent 20 years in power sector, he can easily be the judicial member of CERC or the regional electrical regulatory councils. Likewise, a person who has spent time in FMCG, he can easily be a judicial member in terms of forums, state commissions, national commissions. So you have to utilize their knowledge. And likewise, they're very complex scenarios. For example, port is a very complicated sector. Customs is a very complicated sector. So the person who have handled ports and logistics and customs, those DCs, those in-house counsels, they have spent 20, 30 years there. They understand those nuances pretty well, and they understand how regulation impacts the corporate and how corporate are misusing also certain loopholes. So he understands both the perspective. So if such persons are given the tribunal rules, like for example, GST tribunal again, these people are brought as judicial member in those tribunals. That will always be helpful in larger justice delivery system, and the problem of vacancies which are there right now can also be taken care of. Therefore, I feel it's a win-win. Though right now, whether they should be elevated as High Court judges and Supreme Court judges, there may be a question mark because GCs, as of now, I feel, is now somehow mutated into a different community altogether. So they understand litigation, but they are not litigating as such because they are not going an court. And then art altogether. So that court craft is a very different art. I feel right now, I don't think the GCs will be capable of handling that court craft. There can be exceptions. There are exceptions always there. But as a general, because they're not doing in and out, as you rightly said, that there are very few GCs who will be doing litigation hardcore. Because 80% of time of ours is generally in either an M&A deal or in some acquisition or contracts or claims or such correspondences or regulatory policy advisory work or liaising with the government about some regulations, etc. Most of the work is spent here, and a very little portion of say 20% goes into litigation. They also just go and brief lawyers and ask them to do the court crafting. So therefore, I don't think so right now the time has come for them to be High Court judges or Supreme Court judges. That may come in some time once, but to allow them to go and appear before the court for their clients. First, make those amendments in the Advocate Act, allow the GCs and in-house counsels to appear for their own clients. And once they understand the court craft, then if the pool is right, talent is right, you can elevate them. But these tribunals, as judicial members, definitely they can be there because judicial members' role is very similar to what an industry expert does. And therefore, like a technical member is there, a judicial member should be from the industry if the person is capable enough. And it should not only be retired judges or maybe lawyers. That should not be the case. That's what I feel.
No, absolutely. Very point. I think also I must say, GCs normally try and avoid litigations that are possibly mandate come from top, or they think that the cost of litigation is too high, or it might impact the whole reputation as well. We never know how the evidence will play out. So I think GC is playing a role of in the judiciary can give a lot of positions which are fulfill a lot of positions which are vacant as of now. So and from there, if I talk about your current role where you work on contracting, and my experience is that your contracting work will be very different compared to a normal contracting, because all your contracts must be very detailed and differently drafted, and going through days and weeks of drafting and then negotiations, working with law firms and redlining, maybe having 5 to 6 7 parties, stakeholders in the whole discussion. And then I've also heard that even a comma and full stop mistake can lose you a $1 billion deal as well, or you might lose a case also of multi-million-dollar, even there is if for a very minor mistake. How do you handle this complex role of making sure that contracts are drafted properly and you are protecting the interest of your organization, and also giving a fair chance to the counterparty as well, to make sure that they also not taken for granted, or the larger firm is not squeezing the smaller firm.
Wonderful. So you are right. So I'll explain this. So right now, in my current role as a General Counsel for Cube Highways, so there are 4 departments that report into me. One is obviously the legal department, which handles all the M&A, litigation, every single thing, what a legal department does. Second department is the contract, claims, and risk management department. So whereby all of our contracts, all those things are taken care of. And interestingly, the person who heads this department is not a lawyer. He is, or she is rather, an IIT Delhi graduate. So it's a civil engineer who is handling all this contract. Well, we are a civil engineering company. I'll explain about Cube in some time. So that second one is contract, claims, and risk management, whereby we have to see it from that perspective. And obviously, we take help of legal department, and it ultimately reports into me, so I can see the legal nuances in those contracts. The third department is compliance, ethics, and investigation, whereby we make the entire compliance framework. And fourth department is the insurance department. Now, what we do, what Cube Highways, what we do is, so we are a Singapore-based company. So we have a lot of foreign investors like Abu Dhabi Investment Authority, investors like Mubadala, the sovereign fund for Abu Dhabi Crown, BCI, which is a Canadian pension fund. We have earlier we had IFC, also World Bank invested into us. Then the main shareholder is I Squared Capital, which is again huge $45 billion AUM private equity fund. So the huge funds we have, and then Japanese consortium is there. So we have investors across the globe, big PE funds and World Bank and sovereign funds and pension funds, Japanese consortium who have invested into us. Therefore, the money comes to Singapore first. And then in India, what we do is we acquire road assets. We acquire the TOTs, that is tariff or toll road projects, which is, so NHAI comes with various projects whereby you have to construct the road and then you can collect toll for next 30 years. So that is what we do, the TOT and the BOT and the HAM. That is what we invest into. So we either do a bilateral deal, purchase a road asset which any other bidder has won, and take those roads in our portfolio, or directly bid with NHAI TOT bids and get those roads. So the idea is get these roads, construct these roads, or maintain these roads, and then collect toll for next few years. So this is primarily our business model is. Now here, you see the contract perspective, rightly said. Now from the contracting perspective, the first is the money flowing to Singapore coming there. So that requires financial documents to be made. Different parties, different investors are there. Then from Singapore, the money is going to come to India to either it's a bilateral deal. So we are purchasing an asset from Indian seller. So obviously the entire SPA, SHAs, all business contracts are going there. Then once we have acquired the asset, then we have to get the EPC done at times. There will be EPC contracts, and there are O&M contracts. So those contracts are very heavy, very important, and they're high ticket contracts. So infrastructure, every single thing is always 500 crores, 700 crores, 1,000 crores, 1,500 crores. Every single contract is of that value. So infrastructure is a very heavy capital intensive work. And therefore, as you rightly said, the charge they can cost very dearly. If unintentionally or if you've not seen something properly and something has gone wrong, and thereby you have taken some obligation of paying some something on you are getting on your scope of work, then you're gone actually. So then you have to do that because contract says so, and the other player will take you to task, and that may cost very dearly. And that is the reason why we have a specific contract means department. We have separated from the legal department. Because now this person understands the legal nuances and more so the operational nuances. This person is an engineer who understands, okay, when you're writing these things and writing this is what the monetary terms it means this. That are we taking this responsibility on us or it should be given to someone else? So the lawyer is not in a position to understand those engineering nuances. Anything like bitumen contracts, because that's something only engineer can understand and appreciate those facts and see whether those things are properly reflected in that 120 pages of contract. It's very difficult to read those contracts also. So therefore, this department is specially made and a specialist of making those contracts, understanding those contracts, and see what sort of obligations are there, and then to handle the entire contract lifecycle management, the entire CLM. That what are the contracts, what are our obligations, what are the other parties, if some force majeure has happened, whether notice has been given properly, or whether we have received any notice, is there a change in law, whether right notice have been given, whether we have taken care of those things, and likewise, all the obligations pertaining to a contract till the contract gets over is handled by this department. And that's why, so you have not said so, but there are a lot of CRM tools available in market, which I'm really inclined to use those kind of tools also. We are right now exploring few, but then therefore Volody and all these tools become so handy for us. And that is why I really encourage people to use these things, because now time has come that from manual kind of a monitoring, it is better that let all these tools take place. Because legal tech, AI, they are not going to take over in coming times. And if the GCs are not aligned or not gone to these ideas, I feel they will lag behind in times.
Excellent. I think you made the right point, and I completely agree with you that having a tech solution and AI is very critical for a GC role. And this is a news to me, Mukul, that you have a separate department for contract claims, which is unheard of. And then I think it will not only help the legal counsel, but will also help the GCs and possibly the CXOs as well. Any other infra company CEO looking at this video, he will definitely make sure that there is similar department in their company as well, because certain contracts, GC can't define. They cannot, figure out what it will have impact on the whole claims, etc. So do you need experts like engineers, or maybe for that matter, pharma, or maybe medical professional, or anybody else who, in whichever industry you are in, you need one expert of that industry who work along with the lawyers and the GCs to make sure that the language is drafted properly.
Perspective, the first.
Now, coming to the next question, Mukul, when you work on your kind of business, you cannot have a luxury of having, a standardized template. But, many companies who are doing standard businesses and they don't need really, specialized agreement for each transaction. Do you think there is a need to have a standardized template, and do you think those templates should be reviewed regularly, or you think that anybody can use any template and they just come back to legal department to say that this contract is signed now?
No, I totally agree with you. Standardized templates are required. Even a company like us also, or any other big corporate also, you should always have standardized contract. Obviously, they are open to negotiation and you can negotiate things. But you should always know that these are the 30 clauses which are required in this kind of an agreement.
Right.
That standardized template should always be there, whether it's an SPA or an SHA or even an EPC contract or an O&M contract or a P fund financial document, and the loan document, any project finance document, financial agreement, project agreement, whatever name it is, it may be. You think what is required. So GCs should find out that, okay, these are 20, 30 different set of contracts which are regularly used in my sphere of work. So for those 30 contracts, there should be 30 templates available, which talk about their going position, and then they can negotiate this with the other side, and then accordingly give and take can happen. But then they should definitely have those templates, because otherwise you will then slip off on something important. And as you rightly said, especially in infrastructure, where the contracts are so big, you cannot commit that mistake. If something really go amiss, it can bite you very badly later, and it can cost you huge. Therefore, standardized templates are the need of the hour. You must standardize your contracts. You must have those templates ready, and then keep on negotiating based on those templates. Obviously, when you negotiate, like if I send a contract to you, you have 10 points, and you can say, no, I'll agree to this, I'll not agree to this. We can negotiate. But I am not having any template whatsoever. Maybe a risky position for me, and likewise for you also. Because then if I send something to you, you can check against your template, and you can see, okay, these 10 points are acceptable. These 2 points we can let's fight on, or these 2 are complete no-go. So likewise, so that's what the template is required for a systematic approach to contract.
So no, that's very helpful. Now since you are on contract drafting, Mukul, and a couple of things which seems to me a new normal. Starting COVID, there is a need to look at force majeure clause, which was always there, may not be there, etc. But it was never enforced, and there's so many geopolitical issues happening, Ukraine, Russia, and now, Gaza and Israel as well. And then some other disruptions keep happening, sanctions are happening, and then you have a couple of countries involved where you have investors from various countries, you've got fund which is coming through Singapore, or you got business in India. So, and then you might have your counterparty who's got investors from other countries as well. So, in such situation, how do you handle the geopolitical issues which does not impact your contracting process, and also does not create any litigation at later stage? This also leads to how you handle jurisdiction point, because sometimes someone insists for a jurisdiction which may not be favorable to you. So what? Just throw some light on this. What do you think about it?
Very, very interesting point, and again a very pertinent question that you asked. And I'll give, before answering this question, I'll just give some light to what have happened in past.
Yeah.
COVID. Now, to handle this COVID situation, the US economy printed a lot of dollars. I don't know, trillions of dollars they've just printed, and that caused huge inflation there. And that inflation has such a ripple effect that it caused a lot of problem in that country, and that trickled down to even India, and especially people like us who have investors in US.
Okay.
M&A deals, and there's an article in Economic Times 2 days back that the M&A space in 2023 has been down 60%. So because of that US economy, which they have to tackle COVID, what they have done in past 2 years, that is impacting M&A today in India, and our M&A space, the foreign M&A space has gone down. Good thing is for us that domestic market is strong, bullish enough, so therefore you will not that much. But then you see the foreign investment or foreign M&A piece, the cross-border M&A piece has gone down that drastically. So that is it has been supported by the Indian domestic market, so therefore the overall net impact is not that big. But you see how the geopolitics impact India. Something happening in US, some decisions been taken in US, and that is now impacting India. So that is a very interesting thing. Likewise, you said about Israel, the West Bank, Gaza Strip, what is going on between Israel and Palestine, Russia-Ukraine war. People thought that it is always a month thing or 2 month thing in Israel, in Russia-Ukraine. But then that 2 months has now become almost 2 years. So they have not, and then all these investments are all sentiment-driven investment. And people become conscious and cautious that whether I should invest right now, should I keep the money tight with me, or should I invest? So everything is sentimental at times, not only always financial things, it's always emotional also, the investments. So therefore, all these things impact. And therefore, the GCs, along with obviously CFOs and the CEOs, the top management, they should be really aligned to these kind of ideas, that what is happening in geopolitics, what is happening around across the world, what may impact them. As I said, something which is completely unconnected can also impact business in India. US economy, printing dollars has had an impact on India. So you can see anything can happen. China can do something. They have China plus one policy, and that has caused harm to China. That is somehow has some advantage to India. But again, you never know if something happens with China. It can again have some impact here. So therefore, you have to always be aligned to these ideas. And whenever you are having any contracts or anything drafted, you have to keep all these provisions at least, so that theoretically you have a chance, a fighting chance, and if such thing goes wrong, you have some defenses. And that's why I always say, whenever you have an international contract, always see whether you have a bilateral investment treaty, and if there is so, take a BIT arbitration agreement specifically in your contract, because then that will help you if something goes wrong. You can, like Vodafone, use the BIT treaty against India, and when a lot of tax were imposed on them, they went to UK and got some orders from the UK courts. So that helped them a little bit. So at least you have to have those bilateral treaties. Like whenever we invest in Sri Lanka or outside India, we see whether we have a treaty. If we do not have, then we invest from Singapore to see whether Singapore has a treaty there, and whether we can take advantage of those treaty provisions. So obviously a GP has to think from all these angles before they come out with solutions. And obviously these solutions have to be found in line with discussion with CFOs and the CEOs of the company. So top line has to align to all these ideas. Rightly said that yes, these things impact, and you have to be dawned to these ideas of what's going on around you and how you can mitigate the risks.
But this is a very interesting point you make, that look for treaties, or maybe do the agreement there through the country where the treaty is there, so that you get a lot of advantage of, having sort of a partnership between. Now, if a few minutes back you talked about AI, and, I just want your thoughts on this, because AI is, creating a lot of hard ones, possibly in the legal fraternity as well, because people think that it might take away their role, and I don't want to comment on it because I have a vested interest there. So I would rather request your points and your views there. What do you think about AI? Does it really a threat to you, or do you think it can be an advantage to you or to the legal community?
Yeah, so I'll start answering this question from an anecdote or other. So see, horses, they are the mode of transport. Alexander came to India on horses, right? In 300 BC, 326 BC. until 19th century, till 1870, 1890, till late 19th century, early 20th century, horses were the main mode of transport, even both for war purposes and for local purposes. Suddenly, cars and mechanized motors came into being, and in just 20, 30 years, in a span of 3 decades, say from 1890 to say 1915 or 1920, in 3 or 4 decades, horses just become extinct as a mode of transport. It was
Correct.
just, they were just gone. And it was always motorbikes or cars or the motor vehicles, which have just taken over. And from 1920, 1930, till date, you will not see any horse being a mode of transport commercially or even for support. So something is going on for thousands of years, or more than that, actually. Maybe, I don't know, from Mahabharata days or Ramayana days, from 100,000 of years, I do not know. So that has just gone extending 3 decades or 2 decades. So a mode which was, and when I'm saying horses, not only horses, it's the entire industry along with them. There were horse drivers, there are chariots, there are vehicle makers, there are horse shoemakers, there are this blacksmiths who will fix those things, and there are a lot of horse guns will be there, so cleaners of the road highways to make the roads according to horse. So there's a complete industry in horse feeders, grass, taking care of horses, whatever actually. So the entire industry was there along with this. It was not only the horse. So the entire industry became extinct. A 1,000-year-old industry or a 2,000-year-old industry extinct in just 2 decades. And that is what the capability of technology is. Now, do humans suffer? Do those horse riders or those persons do really become jobless? No. They upgrade themselves with a different skill set, and they become very modern people. They understand the skill set of driving. It's a very, very complicated skill set, not an easy way to drive things. But then we understand how to drive, and now we are driving. It's very easy. It's just nobody finds driving a car that complicated. But if a person from, say, 1,000 years comes, 1,000 back comes from a time machine and see here, he'll find it very, very, very fascinating that how a person can drive aeroplanes and cars and vehicles. So we evolved. We have evolved that skill, and it's so natural now to us that we do not find it we find it very normal actually. Okay, you're driving a car, what's the big deal actually? So it is that thing has come. Likewise, we should take AI, because AI is something, whether you like it, you do not like it, it is going to come and going to take you away actually. Either you understand, evolve yourself to a better skill set, or you're still a horse rider, that is the only skill set that you have, then ultimately you will become jobless. So it's up to you as an individual, because AI is going to come, is going to take you over, is going to disrupt the market completely, and you never know. It can be 5 years, it can be 10 years, it can be 2 years, 5 months, who knows when AI is going to hit you that badly. So better be drawn to this idea, understand the technology, integrate it, and I feel that in coming times, we'll see that all these mundane legal things, mundane contractual things will not be done by humans. It will always be the machines, the AI, the robots who will be doing all these things, and you have to then think more strategically, more intuitively. If your only skill set is researching and knowing case laws and finding out case laws, that skill set is going to completely get extinct. You have to now think how to apply those case laws, how to be more intuitive, how to be more strategic, because then that is what is going to take you for some time. That is what I feel, that AI, the time has come. It is going to come and going to disrupt the legal industry.
No, I think I like the way you kind of gave example of horses transportation system to today's transportation system, and I think it is going to apply exactly the same way. And I think you're absolutely right. It will not take away the job. It will definitely remove your mundane job, which no one likes to do. Everyone wants to do a quality job or a strategic role, or wants to add value to the whole process rather than looking into case laws or doing research work, etc. Let the AI do that role. And in even when we work in our company, we coming up with a solution where even redlining is being done automatically, and this is what is needed. You don't want someone to read the whole contract to redline it. Let it be done automatically, and let them come with a solution how to handle that clause rather than working on hundreds and thousands of pages of agreements and redlining. It doesn't make sense. So thanks. I think that's a very good. It will help the whole legal fraternity globally. My last question, is towards Mukul on the CLM. I'm sure in your current role or in your previous role also, you must have seen so many CLM solutions, and you must have on your own, personally judged the advantages and disadvantages of those. And so, what is your perspective? And I post-COVID, I'm sure your thinking must have changed. But I just want to understand your independent perspective. What do you think about ACLM as a software for the legal fraternity, and do you think it is useful, or to what extent you should use it?
PLM software is something which is a necessary software. Like like if you see any legal department now in the country, they'll always have all these legal research softwares like Monopatras
Correct.
and SEC Online. They can have anything, whatever they like, but they'll always have at least one of such softwares because you need to
Correct.
search case laws. Likewise, a CLM is that important because you cannot have a legal department or a contract department whereby you have we are doing all these things manually because the contracts are many. Even any company, even if it's a routine contract, there's so many contracts which will be coming. There are a lot of POs, work orders, purchase orders, service agreement, engagement letter, all small contracts will be there. And then again, complex contracts, EPC, ONM, and any other SHAs, SPAs, and any big contracts also will be there. So, but the volume is always huge in any recent company. Any company which has 1,000 crores turnover or 500 crores turnover will have a lot of contracts that they have to handle. So therefore, once you have entered into a contract, obviously you have to monitor that contract. Okay, that these are my obligations, these are obligations of the party, and this is how it is ending. So there are so many things that even a simple contract will pertain. Okay, when it is ending, when it is starting, what are the obligations that you have to do? What is the scope of service which you have to either take or to give? What are the money? What are the payment terms? When you receive the money, when you pay the money, when advance is given, what is the treatment? So all these things will be in the contract, and to manage those contracts manually is a very difficult task. So I always feel that CLM is something which is required in any company. And CLM is not only legal departments work; it will integrate maybe other departments also, like financial department. Financial department has a lot of financial documents. The HR also has a lot of documents. So maybe they can be a single tool which can all these things are ultimately contracts. And employment engagement letter also a contract only. Even a background verification, what they do is the contract only. So like so they can integrate, like invoice can be a contract. Invoice can have certain terms and conditions that are also. So all these things can be integrated into one single solution. But this solution, the need is there. Definitely a CRM has to be there. And at least I've seen in all the larger corporates, they are having some other tools. So there's some tool or the other which will always be there. Either they'll make something in-house or they will have some kind of a customized tool with parties. But there will be something or the other. Obviously, the trend has just started, especially after COVID. I'll say in the past 2-3 years, it is now starting, and people are getting more aware about such things, especially when work from home is there and all this stuff is there. So I'm thinking that this is coming. But next 1 or 2 years, I clearly see that CLM will be a commonplace in all larger or mid corporates.
Excellent. I think very valid point, and I also see this post-COVID. The demand has picked up very significantly, and we've got customers every size, small, large, big, medium, globally coming to us for this solution, for coming up with very, very business specific problems, which are, I also, enjoy meeting customers because when we talk to them, their problem, when I hear their problem, I think we never knew these problems. If you go to a pharma industry, they've got a different problem statements or use cases. We go to a telecom industry, different use cases. Go to auto CLV, different use cases. But everyone needs it, and I think nowadays you cannot run any function without technology, be it a legal department or the finance or admin department or any other department. I think you really need this. So Mukul, thank you so much for your time today. I think we spent almost 1 hour, and this is thank you for taking out 1 hour of your Saturday. So very appreciate it for your time, and I'm sure this will help a lot of people, especially in legal fraternity and the CXOs, to take a lot of bites from it, insights from it, and use some of those guidance what you've given for their day-to-day professional life. So I really thank you for that.
My pleasure. Thanks a lot for having me, and thanks for this initiative. Thank you so much, Mr. Sharma. Thanks.